Okay. Well, good morning, good afternoon, good evening, wherever you are, I guess, on all continents. We are just starting this webinar session from Geneva, from one of the major hubs on the water policy and water diplomacy. And we are really honored today to have with us distinguished speakers. My name is Jovan Kurbalija. I'm the founding director of DiploFoundation and Geneva Internet Platform, and we are honored to provide technical and hosting support to the Water Hub and the University of Geneva Faculty of Laws. Today, we will address the question of prevention and settlement of water dispute, the role of joint water course institutions. And for this discussion with us, we have a panelist, Dr. Komlan Sangbana, a research fellow at the Platform for International Water Law and Geneva Water Hub, University of Geneva. He's also consultant of the Secretariat of UNECA Convention on the Protection and Use of Transboundary Water Courses and International Lakes. Welcome. Next to Dr. Sangbana is the Dr. Mara Tignino. I'm sure that you know Mara quite well from the course. She is the senior lecturer and coordinator of the Platform for International Water Law at Geneva Water Hub, and she is from the Faculty of Law at the University of Geneva. Next to Mara is Dr. Alistair Ryu Clark, professor at the University of Northumbria and legal advisor at the Secretariat of the UNECA Convention on the Protection and Use of Transboundary Water Courses in International Lakes. He will focus in his presentation, and Mara will introduce it later on how the Mekong River Commission deals with development of hydropower infrastructure by riparian states. And Dr. Sangbana will focus on how joint water constitutions may contribute to the peaceful settlement of water disputes. And it is really promising and interesting. I'm not specialist for water issues, but I'm international lawyer with interest in the global governance and development of institutions. Therefore, I'm quite keen to hear from our panelists more on these issues. I would like now to invite Dr. Mara Tignino to tell us more about Water Hub and other developments.
Thank you, Jovan, for the nice presentation. So it is a pleasure to meet with the participants of the online course through a webinar. So maybe we are now more close, and I really thank you for all the interaction that we are having through the course. So I would like to present you very briefly the activities of the Geneva Water Hub. So next, please. So the vision of the Geneva Water Hub, it is to promote water as an instrument of peace and collaboration, and this is the vision of the Geneva Water Hub. Next, please. So the idea is to develop an hydropolitics agenda, and we focus our activities on the prevention of water conflicts. So this webinar is really in line with the vision of the Geneva Water Hub, and promoting the water as an instrument of peace, as I just said. Next one, please. So we have different strategic platforms and functions of the Geneva Water Hub. So we have the education knowledge platform that is this course is part of this function. Then we have the networking, so we really benefit from the position of Geneva, and a think tank function with the organization of various conferences. Then you can see the other two aspects, so the establishment of the Global High-Level Panel on Water and Peace, who rendered the launch of the recommendations of this panel took place at the beginning of September. Then something unique that we could say about the Geneva Water Hub is also the program that we have on Art for Water and Peace. So we have a symphony on water and peace that you can listen on YouTube. So next slide, please. So the functions, I've already explained this. So next Next slide, please. Here you can see the members of the panel, and as I said, the report, A Matter of Survival, was presented in Geneva on the 14th of September. Next slide, please. So here you can see some of the chapters of this report. I would like to underline two of them. So the water in armed conflicts, the protection of water in armed conflicts, and we will have some part of our course is also dealing with this question, and of course international water law and transboundary water cooperations. And then you can see other chapters on people's diplomacy, the importance of quality and quantity data, financial innovation for water cooperation, and then the final chapters on all the recommendations. Next slide, please. So here we have the agenda, so it was already mentioned, and we have two specific questions that will be asked to our two panelists. So the objectives of the webinar are in line with the general objectives of the our course. So we want really not to foster reflection on the legal mechanism that aim to prevent and solve water disputes. And in particular in this webinar, we would like to underline the role of joint water course institutions. And as we have already done during the discussion forum, we have distinguished between diplomatic and judicial means. So I would like to underline only two provisions from the two global conventions, so the UN Convention on the Law of the Non-Navigational Uses of International Water Courses, so Article 33.2. Next slide, please. And next slide. Sorry. Yeah, not the. Yes, this one. In particular, this provision refers to joint water institutions, so was really the source of inspiration for our webinar. Next slide, please. Then we, so you can see that when negotiations fail, we have the resort to judicial means like the International Court of Justice and arbitration, and the decisions of these judicial bodies are binding. Next slide, please. And then we have the UNEC Convention on the Protection and Use of Transboundary Water Courses in International Lakes, and we have two pillars of the Secretariat of this convention. Then I would like to conclude with the Indus Waters Treaty that includes a very specific method to settle water disputes that include both diplomatic and judicial means, and in particular the role of the Indus Permanent Commission. So next slide, thank you, and I give over.
Thank you, Mara, for really comprehensive and excellent summary, in particular for framing our discussion, and I would say course discussion, into broader framework of the report, activities related to report. And it is always great for students to study in a way, just to have just-in-time course, because we have an important development which is related to the report, which was presented in September, as you indicated. And they can relate to those developments while also reflecting on broader theoretical and other issues related to water law and water diplomacy. As you indicated, this interplay between diplomatic and the legal aspects. And I think this sets a lovely sort of scene for our first presenter, Dr. Sangbana, who will, as I indicated, reflect on how joint water course institutions may contribute to the peaceful settlement of water disputes.
Thank you. Thank you. Good morning, everybody. First of all, I would like to thank. It's my pleasure to be here to share some things, some elements of my books, my new book published, Protection of Water, Transboundary Freshwater Against Pollution. This book here. So most of the element I will share with you is you can find it more details in this book. And thank you also to Mara to invite me to make this presentation. So first of all, it is important to notice that the establishment of basin organization and commission reflect the perceived need or willingness to cooperate to manage shared water resources over several state territories. Whereas the scope of cooperation was relatively narrow in the 19th century, it gradually broadened through the 20th century as a result of the increased use made of international water courses. And one of the most important element of this evolution is that the prevention and settlement of disputes are among the contemporary functions assumed by those basin organization and commission. In concrete terms, this phenomenon I've called in my book the internalization of the dispute settlement consists to seek solution to dispute within the basin organization and avoid recourse to a traditional third party such international tribunals to settle the dispute between member states. By doing so, the basin organization contribute to maintaining the spirit of cooperation between the member states. As already the Professor Chinino mentioned, the 1997 Convention on the Law of the Non-Navigational Use of International Water Courses underlines this role. So Article 33, paragraph 2 can be read as follows. If the parties concerned cannot reach agreement by negotiation request by one of them, they may jointly seek the good office or request mediation or conciliation by third party or make use, as appropriate, of any joint water courses institution that may have been established by them. So the point I would like to underline here is that the 1997 Convention provision stressed the importance to recourse to those basin organizations at the first stage before a referral to a court or tribunal. Now, how does this internalization of the water dispute within basin organization take place? Some organizations exercise a dispute resolution function as it is explicitly provided for in the constitutive test. An example is the 1995 Mekong Agreement, who foresees the primary role of the Mekong River Commission through its various bodies for making every effort to resolve a difference or a dispute. But I'll let Professor Clark will probably come back in detail on the Mekong region. Another example is also the case of the 1975 statute on the river Uruguay. In the pulp mills case, the court underlined the central role of this statute of the Administration Commission of the River Uruguay, known as CARU, and declaring that at the proposal of either party, the Commission can act as a conciliation body in any dispute which may arise between the parties. We can also mention the Niger and Lake Chad Water Charter, which provide a clear mandate to their basin organization, namely the Niger Basin Authority and Lake Chad Basin Commission, to intervene as mediator or provide good office when disputes arise between the states. Moreover, the 2008 Niger Water Charter provide a very innovative and sui generis mechanism of dispute settlement. According to Article 13 of the Niger Basin Water Charter, if no solution have been found on completion of the good office mediation and conciliation procedure, the dispute shall be submitted to the Permanent Technical Committee, which shall propose a settlement to the Council of Ministers and the Summit of Head of State and Government after 6 months from the time the Executive Secretariat request is to propose a settlement. In some instance, just a few words regarding this provision. In some instance, the recourse to the Permanent Technical Committee in the Niger case can be compared to a conciliation mechanism. However, contrary to classic mechanism of conciliation, recourse to the Permanent Technical Committee here is not initiated by the parties, to the dispute but by the executive secretariat of the Niger Basin Organization, which is an implementation body of the organization. This approach is really interesting because it highlights the capacity of an implementing body to take the initiative in dispute settlement between member states, a capacity generally reserved for political bodies. It shows also the effort of the organization to find out a solution to the dispute through a voluntary and proactive action. For other basin organizations, such function of in dispute settlement may result from practice as a response to the will of member states. This function is generally understood as being linked to the achievement of the object and purpose of the juridical regime for the protection and management of international water courses. So it is an essential part of the general scheme put in place. And quite interesting is this trend reveals also that member states have been willing to have basin commission engage in preventing and resolving dispute. And as an illustration, I can mention the role played by the Senegal River Development Organization in the dispute over the fossil valley between Senegal and Mauritania. This dispute concerns Senegal plan to use the Senegal River water to revitalize the dry valleys of Ferlo, Sine, and Saloum. Mauritania denounced the project, considering that it violated the 1972 convention, and request from the Senegal to suspend its implementation. And in this case, OMVS helped resolve the dispute through its good office, and the Senegal finally put the project on hold. So we had observed that Basin and Commission play an increasing role in the water dispute settlement. A question which arises, probably I will finish by this development. A question which arises is this matter. In this matter is the relation between the exercise for dispute settlement by the Basin Commission and that of recourse to a judicial mechanism such as international arbitration or the International Court of Justice. The International Court of Justice dealt with this issue in the case concerning the land and maritime boundary between Cameroon and Nigeria. In this case, Nigeria presents a number of preliminary objections to contest the court of jurisdiction. Among them, the third objection asserts that the Lake Chad Basin Commission had an exclusive jurisdiction rational material over dispute involving borders question in the Lake Chad area. The court rejects this assertion by stating that whatever the nature, the existence of procedure of regional negotiation cannot prevent the court from exercising the function conferred upon by the Charter and the Statute. United 1. The judicial organ, so the ICJ on the basis of the Basin Agreement, the LCBC Agreement, in question and the practice of member states rejects that the Lake Chad Commission had exclusive jurisdiction. In doing so, the court emphasizes the need to take into account the content and practice of each basin agreement. This varies significantly in terms of mechanisms for resolving disputes. In the practice, we can see, for example, the statute for 1975 on the River Uruguay provides explicitly for the International Court of Justice to potentially assume a role when the party failed to reach agreement within the 180 days following the notification to the Commission. Also, the 1960 Induced Water Treaty adopts an approach providing for the use, in some cases, of a neutral expert, in other cases, recourse to arbitration, and in the event that parties are unable to settle their dispute within the Commission of the Indies. And now to my last point is that here the main point that we need to be stressed is that the phenomenon of internalization of water dispute within basin organization is not intended to replace or overshadow mechanism external to the institution. They must be perceived as complementary tool to achieve a peaceful dispute settlement. Thank you. Yeah.
Thank you, Dr. Sangbana, for this really interesting survey. And I was visualizing while you were talking some sort of a Swiss knife, Swiss military knife with the different tools, and you outlined some like good offices, commission, neutral experts, mediation. Therefore, maybe for some of the future courses, we can think of the Swiss knife with different tools that we can visualize what is available for countries to address the dispute. And in particular, it was interesting, this interplay between, let's say, political level or three levels, secretariat level, juridical level, and overall political level. And that in a way, elevator, which you can move issue from the addressing it immediately towards the ultimately International Court of Justice. And I think it was very, very rich presentation with quite a few examples. Thank you. I'm sure that there will be questions just for our participants. While we are going through presentations, you can pose the question, and our colleague here, Dr. Radu, will pass the questions to the panelists. Therefore, you can immediately, when you think that some issues should be further elaborated, or you have a concrete question, just pose this question, and we'll ask later on after the second presentation by Dr. Alistair Hugh Clark, who will focus on the Mekong River Commission as one of examples, concrete examples of conflict resolution.
Thanks very much, Jovan. So, yeah, what I want to do is really give an example of how the Mekong River Commission has addressed some of these issues that we've discussed specifically within the context of hydropower. So in terms of the outline, what I'll do is I'll look at, I'll very briefly mention the water conventions. They've been mentioned before, so I won't go into any great detail. Then look specifically at the Mekong experience, the Mekong Agreement and the Commission, and some selected hydropower projects. So if we, next slide, if we look at the RBOs and the 1997 UN Watercourses Convention, the conventions have already been mentioned, and a recommendation from the high-level panel was to promote further membership of these conventions. That might be discussed, I think, in more detail other occasions. But just to zoom in on some additional provisions, Mara and Komlan have mentioned some already in terms of dispute settlement. The Watercourses Convention has a very general obligation to consider, it asks states to consider the establishment of joint mechanisms or commissions, or in Article 8. In Article 24, it requests the watercourse states to enter into consultations with a view to establishing joint management mechanisms. So there's no requirement, strict requirement that those mechanisms must be established, but it's very much encouraged. Within the 1992 UNEC Water Convention is a bit more specific. There's a requirement under Article 92 that the riparian parties establish joint bodies for the rivers that they share with their neighbors. And it also goes into quite a number of, quite a bit of detail in terms of the mandate for these institutions. How the design of the institutions themselves can be quite flexible. It could be a full-blown commission with a secretariat, meeting of the parties, working groups, etc., or it could be something a lot lighter, just simply plenipotentiaries, regular meetings between ministries from different countries. So while the design is quite flexible, there's quite a bit of detail in terms of the mandate. And I won't go through the detail here, but I wanted to highlight two key areas that I think are important in terms of what we're discussing today, and in relation to hydropower, is the 92 UNC Water Convention encourages states to serve as a forum for the exchange of information on existing or planned uses of water or water-related institutions that are likely to cause transboundary impact. So if a state does have a plan, is considering developing hydropower projects, then the joint body would be a forum by which those plans could be discussed, shared with potentially affected states, and the states potentially affected could share their concerns in terms of what they perceive the potential impacts might be. And another area that I've highlighted here is that the parties would participate in the implementation of an environmental impact assessment relating to transboundary waters in accordance with approval of appropriate international regulations. So again, the Watercourses Convention, the 92 Water Convention emphasizes this important role that joint bodies, joint institutions might play in conducting an assessment of the impacts of any given project at the international level. So let's now turn to the Mekong Agreement, the 1995 Mekong Agreement. If you can have the next slide. So the Mekong Agreement, and you can see the map there, was entered into by the 4 lower states of the Mekong River Basin: Cambodia, Laos, Thailand, and Vietnam. China and Myanmar are not parties to the agreement, but the agreement has quite a broad objective. It's basically sustainable development of the basin as a whole. And an important driver, if I can have the next slide, the important driver of implementing the Mekong Agreement is the Mekong River Commission, which is the details are established within the agreement itself. Essentially, the commission is made up of some key bodies. One is the council, so at the highest level have an executive function. The council is made up of members at the ministerial cabinet level within the 4 countries that come together to discuss implementation, the progress of implementation of the agreement. There, under the council, is a joint committee made up of members of heads of department from the different countries, so that has more of a functional role in implementing and overseeing projects. And the Joint Committee and the Council are supported by a secretariat, the Mekong River Commission Secretariat, which provides technical and administrative support to the Committee and the Council. Another important aspect to note is that there are national Mekong committees that feed into the work of the Mekong Agreement and feeds into the Joint Committee to support the implementation of the agreement and projects thereunder. And the national Mekong committees are a focal point for coordinating across different ministries within each country, so coordinating at a national level different stakeholders that are involved in transboundary issues. And then there's also dialogue partners within the Mekong River Commission structure, China and Myanmar, that have some sort of observer status, and also donor partner. There's a donor consultative group which also supports the development and the implementation of the agreement. So next slide, if we can look at then how, so in terms of hydropower developments, how has the Mekong River Commission engaged with these developments? Well, first thing to say is there's been quite a, as you can see from this map here, there's quite a significant number of developments, projects planned, under construction, completed within the Mekong River Basin. Some upstream in China on the mainstream, which fall outside the agreement, and then a number on the tributaries that are already, some that are already completed, and then some on the mainstream within the lower Mekong states, which fall under the Mekong Agreement, that are under construction. And I wanted to focus on those projects because they fall under the rules around prior consultation. So if I can have the next slide, please. So on the Mekong Agreement, if under the Mekong Agreement, if there is a project that takes place within on the mainstream of the Mekong River, it's likely that it has to go through a prior consultation process. So this is provided for within the agreement, and also supplementary guidelines and procedures of prior notification within that have been agreed to by the states of the Mekong Agreement. So if I could have the next slide, that shows the details of what that prior consultation entails. So essentially, the country that's planning the hydropower project must inform the other countries of that project through the Mekong River Commission Secretariat. So the Secretariat there has a role to play in ensuring that all the relevant documentation is received, checking that that is complete, pursuant to the agreement and the procedures and the guidelines, and then sending that out to the members of the Joint Committee in the other states. And then the Secretariat and the Joint Committee play a role, establish a working group and task groups to look at the plans in more detail. They might establish expert groups on particular issues, fish migration, sedimentation transfer, which look at the plans and consider the potential impacts. And then that's a 6-month period. So by the end of the 6 months, the Secretariat receives replies from the other states on the notification. So the other states have an opportunity to say if they have any concerns about the project, to share that with the state planning the project. And then the aim through the agreement and the procedures is that the Joint Committee then seek to reach agreement on the project and plans for the project, and ensuring that it's consistent with the terms of the Mekong Agreement. If there is no agreement, then it can be referred to that higher level of the council, and if the council can't agree, then it's referred to the government to seek a settlement through other dispute settlement means. So if next slide, just to say that there is this detailed consultation process under the agreement, but there's also some broader activities within the Mekong River Commission that look at these issues. And I think two key pieces of work here are a strategic environmental assessment of all hydropower dams, developments existing planned on the Mekong, which was completed in 2010 for the Mekong River Commission, and a council study. So the Mekong River Commission Council is currently undertaking a more extensive study of what the cumulative impacts of all these projects. And then, if I can have the next slide, just to say that there have been 3 projects, Zai Buri, Don Sahong, Pak Beng, all in Laos, that have gone through the prior consultation process. And so there has been some important lessons, I think, learned in terms of how that process works in practice, and each time the Mekong River Commission has looked at ways in which it might strengthen the consultation process. So if I can have the final slide in conclusions. So as we see within the water conventions, there's some guidance on setting up the design of RBOs, but there's also quite a lot of flexibility. But we can see that RBOs have an important role to play in these consultations, in discussing these issues of planned projects, and acting as a forum for sharing concerns between the states planning the projects and potentially affected by the projects. And I think there's some important lessons that can be learned in implementing that process through what's happening within the Mekong and through the Mekong River Commission. So I'll leave it there just to say on the last slide that for more information, you can find more information on the conventions there through the hyperlink, and myself and a colleague, Remy Kinner from Earth Rights International, just published a journal paper in Brill International Water Law Journal on these issues within the Mekong. So I'd refer you to that if you want to find out more information. Thank you.
Thank you, Alistair, for a really comprehensive survey. And what was interesting, and especially for me coming from internet governance field, was this reference to transboundary effect, because in the digital policy and internet governance, we increasingly deal with the question of transboundary effect of the data communication. Therefore, there is an interesting parallel, and I'm looking forward for discussion between water policy governance community and digital policy community, how we can make some sort of cross-fertilization, probably learning much more, because there is a lot of expertise and experience in water issues, while in digital issue we are just starting to develop the new forms. What was interesting is that you mentioned that the design of institution is relatively flexible, while mandate is clear, and this is interesting in a way. Software, what is the mandate, what institution should be doing, it's clear, but hardware, how it can be done through the meeting of party secretariat mandate can be adjusted. And also a summary of what's going on in the Mekong River Agreement was really comprehensive and useful. I will now first ask my colleague Roxana Radu to share with us comments and questions, if any, from our colleagues and audience.
Thank you very much. A big hello also from the online community. We have 16 participants currently logged in, and we have 2 clarification questions for the last presentation from Lavinia. The first one is, why aren't China and Myanmar full members of the Mekong Agreement? And the second one is a series of small questions around the history of reaching this agreement. Has inquiry been used as a means to prepare this agreement, or did the national focus points play this role? And secondly, was there a time limit to reach the agreement, and which institutions established it? Thank you very much.
The questions are asked by?
By Lavinia.
Lavinia, thank you.
Okay, well, thanks for the questions. I think in terms of the membership of the Mekong Agreement, as I say, it's left open, so Myanmar and China are invited to join. I think they've considered that, although I think particularly in the context of China, they've taken a strategy of rather developing their transboundary relations at a bilateral level, rather than enter into these multilateral arrangements. But saying that, they certainly do, as I say, they do have that observer status. They share information. If there's last year, there were water shortages in Thailand, which so China released more water from the upstream dam. So there's certainly some communication. There's certainly that channel of communication through the Mekong River Commission. And so whether China and Myanmar become full memberships full members in the course of time, well, we have to see. But yeah, that's sort of the current state of play. In terms of the means of reaching agreement, yeah, I mean, if it's specific to the consultation procedures on a particular hydropower project, the agreement, the Mekong Agreement is quite clear in terms of there doesn't actually have to be, there's not the requirement that the planning state and the states potentially affected by the project reach agreement, but they must aim to reach agreement. So it's an important distinction. I'm just seeing, yeah, and there's a quote here within the agreement, within the definitions. It says, "Prior consultation is neither a right to veto the use nor a unilateral right to use water by any riparian without taking into account other riparians' rights." So it was a careful line to draw in terms of if it was rather stated that all the states must agree, then the balance of power really falls to the potentially affected states. They could just say no to any projects. So rather the balance is to say, well, you have to have a consultation and discussion, and hopefully that will lead to some consensus. But if that doesn't, then the planning state can go ahead, but on the condition that they still need to be sure that the plans are consistent with the obligations under the Mekong Agreement. And if there's still concerns there, then dispute settlement mechanisms might kick in. I don't know, does that answer? I hope that answers the question, but please ask me for clarification.
Very interesting distinction between aim to and must, and therefore they should put an effort, but they don't need, they are not forced to reach the agreement. I think this is important distinction. We have another comment.
One more question from Francisco Jose regarding climate change and potential impacts on environmental, human rights, maritime borders and territories. How can joint committees help address global issues when global diplomacy fails, which is the worst case scenario? And I think that goes to the entire panel. So if diplomacy fails, could the joint committees do anything about the global issues?
Okay, that's an interesting one, and definitely what we saw in climate change. The question is by Francisco. What we saw in the climate change developments is really interesting. In Copenhagen in the 2009, we had a failure, or what we call it, naive global solution. Then for almost 6 years, we had to go via local, regional, national developments and come to the more realistic global solution in Paris 2 years ago. And that's an interesting dynamics of that could be, definitely we learn a lot about it in the digital policy field, but I'm sure that there are some lessons to be learned in the water governance. Mara, please.
Thank you, Johan. You gave me some time to find an answer. Or
Okay.
So now I have in mind the example of the SAVA agreement, where there are some, I think, a protocol, if I'm not wrong, dealing with climate change, in particular adaptation. So this can be a link, that just you mentioned, to climate change, but at the same time, it is a local answer. So no, we are in between a global and a local response, so a global concern and a local response. And then concerning the human rights, I have in mind, of course, the examples of West Africa, where it's clear in the agreements of the Senegal Basin and Niger Basin Charter that I mentioned, and also Lake Chad. So there is the mention on the right to water. So maybe I leave to Comlan saying something also on public participation, right to water.
Okay. Yeah, thank you. Yes, I think that Basin Commission can play an important role in regard of these issues: climate change, human rights, protection for environment. And as Mara said, we need to make a distinction between the universal response and the local one. And in the local one, these organizations are generally the main place to bring a response to the challenge in the basin. And it is how generally in most of the fora, the UNESC Convention in the report recently stressed the importance to put in place those basins. And to take just few examples concerning climate change, an issue that generally this question bring out is the question of the financing the climate change, why we can do it. And finally, the state found out like solution is to give to those organizations the mandate to plan the investment plan to adaptation to climate change for the region. And in the Lake Chad, for instance, we can take the case of Lake Chad. Recently, the World Bank worked very closely with the LCBC to find out a really implementation investment plan to adaptation to climate change in the region. And concerning human rights also, this is the solution that those organizations suggest is to put in the framework. So I'll say human right to water, public participation, just to put up this requirement in the legal regime. So if you take the case of the Niger Basin Water Charter or the Lake Chad Water Charter, you will see that in the provision they are explicitly mention the obligation for state when the plan was then the want to plan some activities in the basin to take into account the importance of human right to water for local populations, and also to involve those local population in the designing of the project. And so it's finally this basin organization offer a fora. Yes, I would say offer a fora to really take into account this issue at the local, at the basin level.
Thanks. Yeah, great question. And just to complement what's already said, and Francesco, in terms of some follow-up work, just to mention that the UNEC Water Convention has been looking at water and climate quite a lot, and there's a task force on water and climate that's been going for some time now. And under that, in 2015, there was a collection of best practice and lessons learned for in climate change adaptation within transboundary basins. So I think that might be, I think that firstly, and that's across the globe, so I think it shows that the basin commissions are increasly aware of and playing a stronger role in considering climate change issues and at the basin level, and hopefully a useful resource to look at some of the lessons learned and best practice within that regard. Thanks.
Okay, we are getting busy with the questions. Thank you.
There's a very good dynamic in the online room. So we have two more questions. One is from Dawood, who is starting with a comment. There was a bilateral agreement between Tajikistan and Afghanistan from 2010 to 2015, expected to be extended in 2017. But as he saw it through the reports, they were pushed by UNECE to follow and implement the agreement, including data sharing. Is there always a need to push governments, or their will actually matters? Also, in the case of the Mekong River, was there an international organization to push for or follow the application of the agreement? That's question number one. And the second question comes from Ken. Is there a procedure to establish a joint impact assessment in the Mekong River experience?
Also heard in the first question asked by whom? By Dawood, the interesting issue of data sharing, which is currently a big issue in international Geneva in different fields, and not only in water, in health, in environment, in migration, humanitarian field, how to share the data. Therefore, maybe some reflection could be made also on that. Please, Alistair.
Yeah, thanks again for questions. I think I would be very hesitant and wary of using the term push. I don't think that's the role. It's certainly not the role that international organizations can play, and certainly under international law, it is up to the states. The states have sovereign rights to determine which agreements they may wish to enter into. So I think international organizations, including the UNEC Water Convention, can play a role in supporting cooperation between states, but ultimately it's up for the states to decide on that level of agreement. And I think that that's also seen within the Mekong agreement and within the Mekong context. And I think you see quite an interesting shift going on just now within the Mekong basin, where of riparianization, as it's called, is essentially there was a recognition that the Mekong River basin itself was heavily donor driven. So it received a lot of donor funding for different projects on numerous aspects around the basin. So there's certainly been a shift and a recognition that there should be less of a donor influence, and then more of a financial contribution and more of a technical support and expertise should be driven at the national level within the national Mekong through the national Mekong committees that I mentioned. So I think there's sort of an important. I mean, there's two important lessons there. I mean, one sort of from a strictly legal point of view, it's solely for the states to decide on the agreements that they enter into, and then secondly that there's that important balance to be struck around supporting what happens at the basin level and ensuring that there's a sustainable country-led initiative in some of these transboundary basins. There's a question in terms of joint environmental impacts assessment. I think there's I mean, I think there's some good practice where states have worked together to develop joint environmental impact assessments on particular basins. Sometimes that happens at a unilateral level, and it can cause some problems. I mean, I wouldn't go into any great detail, but I think you could look at the case of Argentina-Uruguay on the pulp mills case that went to the International Court of Justice, and there they raised a lot of issues around when an environmental impact assessment should take place, the transboundary nature of it, and link that to notification and consultation. It'd take a long time to go into all the details, so I'll perhaps leave it there, unless others want to comment.
Yes. Thank you. So I think that give more details on some issue. I will just focus on the presence of the Transboundary environmental assessment. And just to mention that in the case of the UNECE Convention, one of the main points that have been stressed by the convention is this importance to take in account the necessity for the riparian state to fulfill this assessment when the their activity in their basin. I think that is really a trend that currently we need to really a really trend in international practice. The ICG also stressed the importance to take this account, the impact and assessment when we plan the activities on the basin. And we today, one of the most difficult issues is because when we take the case of the case of the pulp mills, the ICG stressed the importance to make this assessment and don't provide what is the content of the assessment. And so element that we need to be put in place have to be standardized. If I can use this, we need some standard to really make effective this transboundary assessment on the basin. And for that, the practice today with the Expo Convention and some other treaty practice give some very important element to fulfill this assessment on basin organization. So I think that just stress.
Just to stress something that Komlan said about the ESPO Convention on Environmental Impact Assessment in a transboundary context. We will see this during the course, so I think that there we can really see some good practices in relation to environmental impact assessment, and of course it is also important in this context to have the involvement of local populations. So again, there we have provisions in the ESPO Convention, but also in the ARUS Convention that we also look in during the course in the next weeks. Thanks.
Thank you. Quite a few questions. Okay. Yeah.
So our final round of questions, there are 4 of them, so I would just like to ask the panel to address them quickly so that we stay within the time limit. The first one is from Maria. Does the Mekong River Commission have a role in monitoring comprehensively the water quality and the cumulative impacts of those hydropower projects on the river basin, or is it mainly a body for planning the development of the projects? Question number 2 comes, I believe, from India. Shina Kumar is describing a bit the situation between India and China, having problems sharing the river Brahmaputra, which originates in the Tibet region of China. India and Bangladesh are the lower riparian states which depend on this river. How can non-state actors influence China to enter into a multilateral treaty to share waters on the river Brahmaputra? Then Consolata is asking Professor Komlan to expand on the role of the RBOs and what exactly is their task where diplomacy has failed to resolve disputes. Do government just go to ICG, or do the RBOs offer arbitration of some sorts? And a very final question from Lavinia. Do you think that the Mekong Agreement could serve as a precedent for an agreement over the Indus watercourse? Thank you very much.
Well, our panelists, you heard the questions. Shall we start with the first question from Maria? Who would like to? Alistair, please.
Yeah, thanks for the question. Yes, the Mekong River Commission they play quite a broad role, and Mekong River Commission being the secretariat, the joint committee with oversight from the council have numerous plans and projects which I would say stretch across basin assessments, exchange of information, monitoring, to more looking at issues of planning, particular projects, as I talked about in the procedures for consultation, and they play a role in addressing differences between the parties, and also have a strategy of engagement with stakeholders across the basin, to hear views of non-state actors across the basin and elsewhere, and try to feed that into decision making. And so water quality monitoring is part of that. And also, I briefly mentioned the Mekong River Committee Council study. So I think it's quite important that's at quite a high level. It's a study of the council, so at a ministerial level that we're looking at these important issues around the cumulative impacts of the hydropower project. So that's a very ongoing, extensive exercise in working out, okay, what projects, what dams are already in place, what are the impacts from those dams, and what is on water quality, quantity, what about the ones that are under construction or the planned ones, and consider that as a whole, rather than looking at individual projects. So I think that's also an important initiative, which the aim is to complete that study by the end of the year. I think, so, I mean, in the question, it's a great question, looking at India and Bangladesh and China and Brahmaputra and how you can, how non-state actors can influence cooperation. I think, I mean, as I said before, I mean, the short answer is, well, legally they can force a state to enter into an agreement, but I think there's a really strong role that non-state actors can play, or state actors as well, in ascertaining the benefits of cooperation. And we've seen time and time again that by states cooperating over these projects, the benefits far outweigh any of the potential benefits that states might have if they acted unilaterally. So by working together at a basin level, states can invariably derive more benefits. So I think there's certainly a role for non-state actors there in trying to ascertain those benefits and then encourage the states to enter into those cooperative arrangements. I think, was there something else on?
On this point, Alistair, where you're going to the, can we call it some sort of soft water power, which are played by non-state actors?
Absolutely, yeah.
They can increase the pressure, raise the awareness, make the governments accountable, and that exactly. you consider as one of the important broader push towards reaching the agreement.
Absolutely. Let me think if I've missed any anyway, and I'll pass over.
Yeah, there was a question for Komlan, addressed to you, Komlan, about RBO and ICG, please. Go ahead.
Yes. Thanks for the question. My first point is first objective is to facilitate the cooperation among the European states. So they are not really designed to act in terms of judicial process. We need a kind of confrontation between states. No. So the main point that all the mechanisms that can be developed it's perhaps my point of view, under this basin organization have to be a kind of mechanism who will facilitate cooperation, discussion among the European states. And when we take currently we make a kind of overview of the practice. Something we can say, just one. I think just one unique is the case of the mixed commission between United States and Canada, who have a kind of it's not really arbitration, but we can find some kind of judicial procedure with this commission, because state can refer to the commission when they have a dispute to find out a solution. But in the treaty establishing this commission, this is really say that the decision that this commission will give to state is not arbitration decision. No, it's really a recommendation to help states to implement their international obligations. And the second one point I want to pinpoint is that generally RBOs came before the dispute going to we can say the state universal diplomacy. I think about, if you think in terms of the international diplomacy to international court and tribunals, it's not really the comparison is not really fair, but RBO came before this dispute came out at the universal level. I think that it's all a strategy of European states to, when they have a dispute, they try to find a solution within their basin organization. And we can see this trend really strong in the African basin. And if I take the case of the Niger Basin Organization, the 1986 revised convention establishing the Niger Basin Authority. In this convention, something was stressed regarding the dispute settlement. It said that all the disputes have to be resolved within the within the basin organization and in last resort. So they don't provide any kind of refer to tribunals or International Court of Justice. This is the first draft, but that is changed because the 2008 charter finally opened the door to International Court of Tribunals. But just to show that generally when the dispute arise like that in those basins, the main idea or the main objective of the riparian state is to resolve the dispute within the organization, and finally, when they can just see how can be done by other actors like ICG or mediation by important figure to help them to solve the dispute. So yeah.
Thank you, Kamran. Well, Alistair, you went through your notes. Is there anything that you would like in also in a sort of concluding remark to make? Because we have comments and questions which we will answer in the follow-up, but we have about 5 minutes to wrap up our discussion. And in the mic.
Yeah. So
then Mara, you may.
Yeah, I think. Well, just to sum up, I think. I mean, as I said at the outset, we have these conventions at the global level now, which can encourage and support the establishment of these joint institutional arrangements at a basin level. So I think that's a useful foundation by which more specific basin cooperation can take place. But really, ultimately, it requires the states themselves to have that willingness to engage at a bilateral international basin level. To cooperate over their transboundary resources, and I think hopefully we've shared some of the benefits that can derive from having those institutions in place, having a forum by which you can exchange these the plans, the concerns, and hopefully that goes a long way to resolving any differences that there might be, but it's not the answer. It's still the decision ultimately rests with the states. So ultimately it's up to the states to decide, and the commissions can play a supporting role. So I think there. Perhaps a closing message is the showing within a particular basin, if these joint institutions can demonstrate the benefits of that cooperation, whether it's sharing information, harmonizing that information, developing joint projects, resolving disputes, and I think that goes a long way. And then if that can then be shared across basins, and the UNEC Water Convention is one platform where basins can come together and share their experiences across regions, and then to me that's also a really important way in which these we can further enhance and strengthen the role that these joint institutions play. Yeah.
Thank you, Alistair. I will make reference to this process which is going in Geneva on the questions of data in global governance, and we have in this building on WMO, which is a very nice building. When you come to Geneva, please visit us. We have the setup which basically coordinates monitoring of about 10,000 monitoring stations involved in water issues, from the question of climate change, weather, from Arctic to Antarctic. It's a huge data setup, and there is discussion now in Geneva what different organizations can learn from each other, from monitoring of data in climate field, now in water field, which was for me great discovery today. Also in the field of migration, humanitarian. They have different specific focuses, but ultimately the question is how to share the data within their context. Therefore, it will be interesting to follow up definitely with you and other colleagues on this issue. Komlan, what would be your concluding message from this webinar, and then I'll pass microphone to Mara.
Thank you. My concluding remarks will be, yes, RBO can play an important role in the dispute settlement, but I think that the main responsibility is, first of all, of the riparian state or the state that are really involved in those disputes. So the RBO have a support role, can facilitate the resolution of, generally when you take the treaties, some treaties don't want to say a dispute, but question or issues. And finally, when they don't find out the solution, yes, the dispute arose and can be bring before courts and tribunals. So it is important to have really to circonscrire the role of the RBOs to help them to be really effective in their mandate. And I think that, of course, currently a very important role is played by the UNC Convention, who offers this forum for RBO also. But we have also some useful tools who can play an important role in these issues. The implementation committee of the UNC Convention, which supports the resolution of disputes. It's a kind of supportive tool at the international level, who can also be mobilized by state to find a solution to the management of the shared basin. Yes, thank you.
Just I would like to thank the participants of the course, and I would like also to thank Ms. Monica Nunes that is here in the room for all her support during the course, and of course all of you knows her, and I'm very grateful to her. Thank you, Monica.
Thank you. Well, let me join Mara with thanking all of you involved in the delivery of this webinar. I learned a lot. I'm sure that our colleagues and participants also learned a lot. What I learned, I cannot talk on your behalf, but what I learned is that this is really fascinating governance issue. That there are a lot of cross-referencing with other spaces, in particular space where I'm involved, internet governance and digital policy, and we will follow definitely on that side. But on the course itself, there will be follow-up by Mara and by colleagues involved, Monique and Mara and other colleagues involved in the process, and all questions which are posed and comments which we couldn't manage to answer in this limited time will be answered in the follow-up to this session. Thank you also, Roxana and David, for facilitating this, and Arvin, who is in Belgrade. It's our colleagues who have been facilitating these sessions.